Hey y'all, my name is Ferris Steele Johnson and I use she, her pronouns. And I'm here to talk to you today about your rights as a student in public schools in America. So I'm doing this in partnership with PrideLink, which is an excellent queer advocacy group and queer wellness group in upstate South Carolina. We're very thankful for their work here. So let's get into it. Today, I'm going to talk to y'all about a few things. We're going to discuss some pretty pressing topics for most students when they're growing up in public schools, from harassment and bullying to privacy, freedom of speech, dances and proms. Can you bring your crush with you? Specific protections for trans, non-binary, and gender non-conforming students, and starting a GSA. And then a little bit on what to do if you think your rights are being violated. One really big disclaimer I want to start with, though, is that none of this is legal advice. I'm not a lawyer. That's really important for you to know. In the event that you decide that you think you want to take legal action, it's super critical that you get a lawyer involved. Law is always evolving, always changing, especially during these times and these really polarized moments right now where a lot of queer rights are up for debate. It's super critical that you get a lawyer. Now, I've done my best to make sure that this is up to date, but things are happening even this moment. The Supreme Court ruled on a case this very week that I haven't really had a chance to fully integrate into this presentation. So make sure you get a lawyer. The other disclaimer that I would say is most of what I'm about to talk to you about really only applies in the public school setting. And yes, that does extend to public charter schools as well. Unfortunately, when you're in a private school setting, you lose many of the rights that would be guaranteed to you in a public institution. Now, if you are facing any of these challenges or finding your rights violated in a private school setting, that doesn't mean that there may not be recourse for you. It just means it might look a little bit different than what I'm talking about here today. So thanks for coming along. We're going to get into it. And I'm super stoked to be here with you. So the first thing I want to do is just ground us in a moment in the legacy before us. So if you don't know these two wonderful people that are on the screen, one is Marsha P. Johnson, one of the folks that launched our first Pride, and the other one is Audre Lorde, one of my favorite poets, an incredible lesbian poet. One of the things that is very difficult when talking about laws, especially laws to protect marginalized folks, is that although we may have our rights, that doesn't guarantee that other people will respect those rights. And oftentimes, your very rights, the things that should be granted to you without a question, are the things that you have to fight for. And we come from a very, very long tradition of that, y'all. So there's so much to be proud of, so much to stand on the shoulders of these folks that came before us and be thankful. We're a part of a vibrant culture of revolutionaries and rabble rousers. And so you're not alone. Even if you feel alone, you're not alone. I promise you, there are so many folks that are on your side. And so let's just take a moment to ground ourselves in that legacy and know that we are also building something for future generations to come. And to know that we don't have to feel like we have to beg for our rights. We will organize and we will take them as we have always done. All right, let's go. So the first one, which is pretty important, I grew up gay in public schools in South Carolina. So if you're going through harassment and bullying, just know I've walked that journey with you as well. The good news is that your school does have to protect you against an unsafe environment. You have the right to a safe learning environment. And I want to tell you the story about 6 students who sued their school district and won this for us. So there were 6 students. 3 of them chose to remain unnamed. The other 3 were named Alana, Freddie, and Jeanette. And they were at a school in California. And in 1998, they decided they had had enough. They decided they were going to take on their school district for the gross negligence that had happened to them. These students had been repeatedly bullied for being gay. Alana, in particular, had had a homophobic slur carved into her locker and it took the school 3 months to paint over it. Alana also had death threats and violent threats slipped into her locker, along with lewd images. And when she took this to an administrative person within her school, the person said, "What? Are you gay? If you're not, then stop crying." These students had had enough. So they took the case to court. And the amazing thing is that they won. The school ended up settling. These students didn't simply want to be restored for damages. They also wanted to implement something to help students that would come after them, and required that the district implement a district-wide training for schools and school district employees. And so that is exactly what happened. In 2004, the school district had to pay out $1.1 million for negligence, and they provided this comprehensive training. So what does that mean for y'all? It means that your school must stop bullying. If they know about it, and if they know it's persistent, they have to take actions. Furthermore, one of the things that came to light in this case is that the actions for students that were bullying people about their sexuality or their gender presentation were significantly lower than the consequences for students that were bullying folks for other reasons. And so one of the things that was established in this case is that there needs to be some sort of equity. If you're bullying people, the standards are the same, regardless of what you're bullying them for. So these queer students didn't have to suffer knowing that their bullies were just going to get a slap on the wrist. So that is the good news. The other thing, which we're going to talk more about in the future at the end of this talk, is how you document these things, because documentation is going to be super critical if you need to take legal action. So the next thing we're going to discuss is privacy. You have the right to control the release of highly personal information about yourself. This is in particular about outing, whether that's about your sexual orientation or your gender identity. One thing I will say here is that this area is being highly contested right now. So there are several things that are in the air. One is that we don't have an explicit right to privacy in the Constitution. However, legal scholars have established a constitutional right to privacy by kind of looking at various amendments, especially in the Bill of Rights, and thinking that they have this implied right to privacy. So we understand that the courts have laid out a framework for the right to privacy. That's what gives us bodily autonomy, the ability to keep our medical records sealed if we need to, those sorts of things. And so when we get into it, there is a best practice among educators, and this comes from the National Association of Secondary School Principals, that a student's transgender status, legal name, or sex assigned at birth is confidential medical information and considered personally identifiable information, and therefore cautions any disclosure of that information. So y'all should know that even though there isn't this long history of legal precedent that says that people can't disclose things about you, there is at least a best practice for educators. Now, it's currently being debated, and we'll probably see in the next year or two. Currently, it's June of 2021. We'll probably see in the next year or two folks take cases to court of schools forcing students to out themselves to either their parents, their guardians, whatever it might be. But right now, you need to know that educators at least have a professional best practice of not outing students. And there is at least some framework that you have the right to privacy about disclosing highly, highly sensitive information about yourself, especially information that could jeopardize your safety, whether that's around safe housing or whatever it might be that's happening in your home. So this is an area that we're going to keep our eyes on, but just know that there still might be recourse for you if someone is to out you. Next, we're going to talk about freedom of speech, and I'm actually going to have y'all watch a video really quick, and then we're going to come back to it. But the video we're going to watch is about the Tinker case, which established free speech for students in public institutions. So I'm going to click play on that really quick, and I'll be back in a moment.
Hey, John, it's Mary Beth.
Hi, Mary Beth. Great to be here.
Yes.
We're going to talk about the armband case. Tinker v. Des Moines.
What an experience that's been.
Hasn't it been? Yes. We never really had any idea it would turn into this, did we?
No idea that this would become such an important ruling for students' rights.
That's right.
So we grew up in Des Moines, Iowa, where our father was a Methodist minister, and then we became Quakers. And so by 1965, I was 13 years old in 8th grade, and John was 15 years old in 10th grade.
And the war in Vietnam was developing steam at that point. People were starting to be killed, and a lot of us wanted to protest against the war. And someone mentioned that wearing black armbands was going to be one way that people would protest.
The principals in Des Moines heard about our plans through the high school newspaper at Roosevelt High School. And so they made a rule against armbands, saying that anyone who wore a black armband to school would be suspended.
That's right. Our dad said to me that he wasn't so sure that I should violate their decision.
So what did you say, John?
Well, I said, Dad, this is just a black piece of cloth, and people in Vietnam are dying. And Dad said to me, well, then for you, it's a matter of conscience. I said, I guess it is. And he said, well, then I support you. You had already left for school.
Yeah, I didn't know. I was really nervous and scared, but one of my favorite teachers was standing at the door with a pink pass to go to the office. And so I took the pass and I went down to the office and my heart was beating. And then I got there and Mr. Willitson, the vice principal, said, Mary Beth, that's against the rules, so take off your armband. So I looked at Mr. Willitson, I looked around the office, and in a great stand of courage, I said, okay, Mr. Willitson. I took off the armband. And the girl's advisor, Mrs. Tarman, said, now, Mary Beth, since you wore that armband and broke the rules, you are going to be suspended.
You know, when I wore my armband, I went to the cafeteria for lunch, and some kids came over and called me a coward and a communist.
We think there were maybe around 10 or a few less that wore the black armbands, but 5 were suspended.
And so we sought legal advice from the Iowa Civil Liberties Union lawyer, and he recommended that we sue the school board in the federal court for violating our First Amendment rights. And so that's what we did.
He really helped us kids feel like there was hope and that we were safe, because by this time, really mean people were coming around. Some people threw red paint at our house. Someone threw a brick through the window. And then one day, a phone rang and the lady said, is this Mary Beth? And I said, yes. And she said, I'm going to kill you. And I couldn't believe that someone was so hateful just because we had spoken up for peace at Christmas time.
We took the case first to the federal district court in Des Moines, and we lost there. And so we appealed to the Supreme Court, and we won 7-2.
On February 24th, 1969, Supreme Court Justice Abe Fortas declared that neither students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate.
And so that's become probably the most well-known phrase from our case.
I was so happy. And our mother went out and bought some ice cream and soda pop that night.
Yeah.
We found a way to deal with our grief, which was to take action. And it helped us a lot. It helped young people to be able to speak up and stand up when the Supreme Court said that they had a right to do that. Hey, John, it's Mary Beth.
Hi, Mary. Great to be here.
Hey, John, it's Mary Beth.
All right, y'all. Thanks for listening in on that one with me. So I love that story because it just demonstrates how young people can take something that's really grieving to them, right? John and Mary Beth were bullied for their stance against the war. And they were able to take that and with that grief, take action, advocate for themselves, and through that win for all students for all time since then. That beautiful quote that you read, that we don't lose our right to free speech when we walk through the schoolhouse door. So what does that mean for you? It means in particular for queer students that we can express our pride. We can talk about queer issues. We can wear things that support causes near and dear to our heart. And we can do all of this without fear of consequence, discipline actions from the school. So what's great about this is that we actually have a case where students have applied this Tinker case to pro-queer, pro-liberation, messages in their school. So there was a school in Florida. This case is known as Gilman versus School Board for Holmes County, Florida. And students there, it was in the early 2000s when marriage equality was generally a very hot topic, especially among young people. And students there were wearing shirts like, I support my gay friends, I'm pro marriage equality, legalize gay. I had one of those shirts back in the day in 2006 that I proudly wore to school. And this school reprimanded these students. They claimed that this was breaking dress code and etc. And these students fought back. And in 2008, their case was decided, and it was decided in their favor. Which is pretty amazing. And I just want to share with y'all a quote that came out of that I think puts so clearly why we have to protect free speech in our schools. Schools are really the first place where we start to learn about democracy and pluralism and the free exchange of ideas. And so one of the judges in that decision wrote, obviously, political speech involving a controversial topic such as homosexuality is likely to spur some debate, argument, and conflict. Indeed, the issue of equal rights for citizens who are homosexual is presently a topic of fervent discussion and debate. The nation's high school students, some of whom are of voting age, should not be foreclosed from that national dialogue. And that really echoes for me a cool case that was won this very week. A student had made a Snapchat story about something that happened at school, not on school property, not on school time though, and it used obscene language. She used the F word. And this case went all the way up to the Supreme Court, and the Supreme Court affirmed again that students have free speech, even when that's happening offside of campus, and even if that speech seems to break some rules of vulgarity outside of campus. So generally the free speech rule says that if you're on campus, if you're in school grounds, in school time, whatever free speech you're expressing can't be vulgar, lewd, obscene. But outside of school, you have the same rights of freedom of speech that everyone else does. And so this student won her Supreme Court case, which is pretty incredible. And one of the decisions that came through on that described American public schools as the nursery of democracy. And I think that's so incredible for the project that we're doing here. It's in schools that we learn how to first be good citizens, good neighbors, and to build community with one another. And so that's why freedom of speech is so critical for us in those spaces. So I just want you to go forward knowing that you have the ability to talk about things, whether that's wearing a t-shirt or whether if you're taking a class on debate and you want to write a paper about trans rights or trans equality, you can do those things. And it's all because of those students that came before us. The next one is a little bit more lighthearted and something that, is a right that I'm really glad that we have because it's such a fun way to continue to participate just in all the joy of being a student. So dances and prom. Can you bring your date to prom if they don't fit the mold of having a heterosexual straight couple going to prom? Back in my day, this was highly contested. Many schools had rules that wouldn't allow you to do this. But the good news is that it is firmly established now that you have the right to bring your crush to prom, so long as that doesn't violate other rules that your school may have, like them being of a certain age. And all of that is thanks to this young man in the baby blue tuxedo there. His name is Aaron Frick, and he was in high school in the late 70s. In his small conservative town, he didn't know really anyone else that was gay and faced a lot of bullying and exclusion. And so he decided he was going to be very, very brave and invite his crush with him to prom. And he knew that this was an act of defiance and sticking up for himself. And he saw it as kind of the culmination of him embracing his own dignity and realizing his own dignity. And he was willing to bring his crush, Paul, who's featured here, to prom no matter what. And I don't think that he knew it was going to take a federal court order for that to happen. But that's exactly what happened. Now, in Aaron's case, it's really interesting. Aaron's principal didn't want Aaron to not bring Paul, not because he was kind of explicitly homophobic. His argument was actually a little bit different. He worried for Aaron and Paul's safety. He thought other students might attack them, bully them, cause violence or harm, or otherwise just be disruptive. And so the principal was more concerned about the safety of them and was saying that's why they shouldn't be allowed to come to prom. The judge himself said that he felt like the principal's concern was genuine, right? He wasn't just putting this on. But still, what's really critical is that the judge still ruled in Aaron's favor. And the reason given was that although, of course, something like this might come with it a risk that other students might act out, two things. One, if students were to act out, become harassers, bulliers, violent, that responsibility for that lies solely on those bad actors, not anything that Aaron and Paul have done. And so it's really clear to, again, place blame where it truly lies. And then second, if we were to honor and say, yes, Aaron can't bring his crush to prom, we have to, what we're doing is we're allowing hecklers to have the ultimate veto in the public square. That if you can get loud and rowdy and violent enough, you can stop anything or cease anyone's civil rights. And so thankfully, Aaron fought this good fight for us, but that didn't mean that people didn't keep trying to make it so that we couldn't bring our crushes to prom. So as I said earlier, even if you have a right that's been explicitly stated, even by very high courts, people are still going to challenge it. It happens all the time. So 3 decades later, there's a Mississippi school. And when they had a student that wanted to bring their crush to prom, a queer student that wanted to bring their queer crush to prom, they decided, all right, well, we can't ban that student. We'll just cancel prom. And the courts stepped in again and said that this was an affront to freedom of speech, freedom of expression. And that school district had to pay out $116,000 in damages and attorney's fees for their attempt to cancel prom. So pretty incredible. Bring your crush to prom, have all the queer joy that you want, and dance the night away. So we're going to get into the next one here, which are protections explicitly for you to be who you are. And in particular, I'm talking to trans students, gender nonconforming students, and non-binary students. You have the right to be who you are. I'm going to be really honest with y'all right now. This area of law is currently highly contested. There is a unified front on behalf of bad actors in government to try to make this the next culture war. And so there are a lot of people doing a lot of amazing and brilliant legal work to fight these cases off that are seeking to harm trans and non-binary and gender non-conforming kids. So you have a lot of people on your side, even though this is currently being debated right now. If you're looking for folks to follow, if you're interested in that, follow Chase Strangio. Chase is one of the leading lawyers on these cases before the Supreme Court right now. So this is being contested. One of the things that's in particular being contested is the story of a young man named Gavin Grimm. I'm gonna let Gavin speak for himself in just a moment by watching his video, but I wanna give you some background. So Gavin began his transition in 2015. He approached his school. They said there would be no problem. He would be referred to by the pronouns that he had told them. He was going to be using his new name, Gavin. He was going to be able to change in the locker rooms that corresponded with his gender and use the bathrooms that he decided to use. But everything went haywire when the school district, the school board, caught wind of this. And this is a really important distinction for y'all to keep in mind. School boards are political. They are elections. Some are partisan and some aren't. Some folks are running as Republicans and Democrats and some aren't, but they are infused with the same politics that are happening everywhere else in America. And so when the school board heard wind of this, it became an issue and it was highly politicized. And all of a sudden, Gavin found that his life was at the center of a political debate. And I'm just going to share with you now where Gavin's story is currently. We're going to play this video.
Ground zero in the fight over transgender bathrooms is this quiet town in Southern Virginia. The unlikely face at the center of it all, Gavin Grimm.
When you realized you were trans, you actually went to the doctor.
I went to a gender therapist who specialized in seeing transgender youth, and it was very apparent to her very quickly that transition had to be done as quickly as we possibly could because I was suffering greatly.
You and your mom went to school. When you were a sophomore, you explained to the school what was going on. And my understanding is your high school was pretty accepting and receptive. Is that accurate?
I was assured that I would be respected at the school. I would be called exclusively Gavin and exclusively by male pronouns.
At Gloucester High School, Gavin initially used the bathroom in the nurse's office, but it was inconvenient to get to from his classes. And since he was already using the men's room at restaurants and movie theaters, he asked the principal if he could do the same at school. The principal agreed, and Gavin says he used the boys' room without incident for nearly 2 months.
For me, it was a matter of going in and going out and minding my own business, as most everyone does in a bathroom.
But then the school board got involved. The school board ruled Gavin could no longer use the men's room. Instead, they gave him the option to use 3 unisex bathrooms, something Gavin wasn't interested in.
The problem is, I'm not looking for a compromise. I'm not looking for separate but equal. I'm looking for the same opportunities that my peers enjoy every single day, and that includes using the same restroom as any other student.
When you first learned your case was going to be heard before the Supreme Court, what was your reaction?
The Supreme Court aspect of it is daunting, if only because it's the Supreme Court. I mean, this could go really well or it could go really wrong, and I have to be prepared for that reality. But regardless of what happens in the end, we'll justify the means, because even if we suffer a loss, we've generated a conversation that's moved the nation in the right direction. And if we win and it's after I graduate, I'm still doing good for a lot of other kids.
So right now, we're waiting to hear back a decision for Gavin's case. Right now, we're living during the Biden administration. We expect that the Biden administration will weigh in to some extent on this in favor of Gavin's right to use the bathroom that corresponds with his gender identity. But right now, this is being contested, and there's an onslaught of anti-trans athlete bills, anti-trans medicine, especially for young people. So we are keeping a close eye on this. Here are a few things that we do know about your right to be who you are at public school. Dress codes can't be used against you to perform gender. No one can say you can't wear a skirt because you're a boy or something like that. Those sorts of prohibitions that are gender specific should not be used to make people perform genders that they're not comfortable in, or simply even to just dress in ways that they're not comfortable dressing. This is not a right, but it generally is seen as a point of respect or caring for a student. There's certainly cases that can be made about it, increasing your safety, your ability to achieve in schools, or that schools should be referring to you by your chosen name and your pronouns. Your school, as we established earlier, has they are supposed to protect you against persistent harassment and bullying. And this includes if people are persistently misgendering you in order to cause you harm or discomfort. And then last, they should refrain in any way from discriminating against you on your identity basis. So those are just some very basics, but we're treading into murky water here because this is currently a contested area of law. So stay tuned and don't give up. Keep fighting. There's a lot of people fighting with you. So we're going to move it along and talk about how you can build solidarity in your school with other students and with teachers and educators and do the good work even within your school. So if you have never been to a GSA, GSA's, though that acronym stands for a number of things. When I was growing up, that generally stood for Gay Straight Alliance. Now many folks are calling them Gender and Sexuality Alliances. So they have different names, but they're all the same thing. For younger kids in elementary school, generally these are called rainbow clubs, which is really cool. So why might you create or join a GSA in your school? Number one, it's a great place to provide support. So GSAs can be a great place for students to share their unique hardships, their unique struggles with peers that understand them and care for them in a safe and nurturing environment. It's a great place to provide some solidarity, especially around issues of harassment and bullying. It's a great place to create community and do fun things together, whether that's attending Pride or watching a movie all together. They're just a really good space for you to continue to build friendships and to build community. And then last, GSAs can take some pretty cool actions together. So GSAs across the nation have done really incredible advocacy work, including things like Teach the Teacher Day, where these students will teach about gender and sexuality to teachers and educators in their own school district. They can do things like screenings of movies or documentaries in their schools. There's so many incredible ways that GSAs can take action and build solidarity in schools. But I just want to let you know that many schools don't want you to start a GSA. There are, of course, folks that don't want these to exist in schools, and they will give you many, many reasons why they think that these should not exist in schools. But you have the right to start a GSA in your school. You have the right to build solidarity with other young queer folks in your school. And so you have this based on the Equal Access Act, which specifically says that if a school or an institution is providing space or funding for some sort of student activities, that they are not able to block other student activities on the basis of whether it being religious, political, or philosophical, contentious in any way. So if there's an FCA, there can of course be a Hillel. If there are, student organizations like Young Democrats, there can be Young Republicans. No one can block this access. And that's what also grants you the right to start a GSA. You have the right, this is guaranteed. This is actually something that we are very established on. You have the right to start a GSA. Sometimes schools might say that they can't start a GSA because it'll be seen as a school endorsing homosexuality. That's the language that they like to use when I was in school. That has actually been taken on by the Supreme Court, and the Supreme Court ruled that the proposition that a school does not endorse everything they fail to censor is simply not complicated. People are rational enough to know that just because a group exists at the school doesn't mean that the school is saying, hey, everyone should go and do that now. There have also been court cases where schools or school boards have tried to say that GSAs are inappropriate because they're discussing sex with young children. That has also been ruled on by the courts. It's understood now and understood widely that that's a discriminatory view, that these clubs don't exist to talk about, vulgar topics. These are places where people with a shared identity and shared experience can come together and find community. These clubs are way more about combating injustice, looking for fairness, and finding friendship than they are about anything like that. And then again, you'll see a lot of schools say that they don't want GSAs because they fear it'll cause controversy. And for that, we return to our friend Adam Frick at the prom, and that you can't give the hecklers a veto, right? So, we have this established clause that says that we are able to start things that may be controversial. And if other people act out in response to that, that's not on us, that's on them. So if you're thinking about a GSA, and I sure hope you are, because they're very, very exciting. And I think there's a lot of cool potential for you to take action on a super local level. What should you do? Generally, most schools have some sort of procedure by which you form a club. You may have to fill out some paperwork. You may have to find a teacher sponsor. You may have to get a certain number of student signatures to get this club up and going. If you're wanting to start a GSA, you should know that the deck may be stacked against you. There may be folks in administration that don't want this club to exist. So you need to do everything by the book and document it all. When you email something, when you get a signature, make sure that you're writing that stuff down. You have dates, you have times, you know who you're talking to. Make sure that you're following all of the rules. That way, if they give you any reason, it's not because of any fault of your own, and it's clear that it's just a case of discrimination. So you should definitely look into starting a GSA in your school. If you have any questions, you can reach out to the good folks at PrideLink. You can find me somewhere, generally on Instagram. And you can also go to gsanetwork.org. They have all kinds of resources for you there. And, I'm just going to talk very briefly before we sign off today about what it looks like to document things. And, there is an inherent unfairness that if you are having your rights violated, that the burden is on you to document these things. But that is unfortunately how the court system works. And so if you feel like your rights are being violated, it is super critical that you document everything. As the kids these days say, save the receipts, get the receipts in order. You'll want to have, if it's a incident of cyberbullying, you'll want all the screenshots that you can get. If it's conversations that you're having with educators, you'll want to take extensive notes, make sure those are documented. If you can have witnesses, if you have an affirming adult in your life, whether that's hopefully a parent, but if not, if you're able to find an affirming adult that can be in the room and be an advocate for you, those are also tools of ways to document things. There are ways that you can ensure that you're protecting yourself, but make sure that you have that documentation. And there are several organizations that can help you out if you need to seek legal recourse. The ACLU is a great one. The Lambda Legal Network, the Southern Poverty Law Center, and locally we have South Carolina Legal Services. They don't always take on cases like this, but oftentimes they will look into educational cases. So there are a lot of resources for you. If you're feeling stuck, if you're feeling lonely, if you're feeling like you don't know the next step to take, please reach out to our friends at PrideLink. There are so many resources for you. So many people have walked these same paths before you, and there is only forward. So as we sign off, thanks for joining me today. I'm going to share with you one of my favorite quotes that comes from the end of a play called Angels in America, which chronicles the turmoil and death of the AIDS plague in America. And it ends with, "The world only spins forward. We will be citizens. The time has come. Bye now. You are fabulous creatures, each and every one, and I bless you. More life. The great work begins." Thanks, y'all. Get out there and get to work and get fighting and find joy all along the way.